Hello, everybody. This is Bruce from Oregon, Bruce the Moose with the Bruce from Oregon show. What's up, YouTube? Today, we have a new episode in the Court of YouTube Comments series. We are looking at the Owens v. Echard Paternity case, which has transformed magically into the state of Arizona versus Owens criminal case. What we are going to do today is look at the comments section on this YouTube video, which is called Why Everyone is Wrong, all caps, wrong about Rule 26. This was a cell phone video posted by David Gingras, lawyer for Miss Owens in the Owens v. Echard paternity case. Of course, he's not her lawyer in the Arizona versus Owens criminal case, but some of the comments may touch on that. We will see, we will look at them, we will analyze them. That's what we're going to do here today. I apologize for the reverb. I'm in a big empty room. That's just how it's going to be until I get into the van, and then I will be the moose on the loose. Let's get into these comments. Now, we went over this video in Lauren Knighty's live stream. We were actually talking about something else. We were doing a greatest hits album for Mr. Gingras, Esquire, when this video popped up in the middle of the stream. So we watched it live. Now, extemporaneously speaking, it was a wild ride, but you can go over there and check that out. And what I want to do is I want to go through these comments, and then I want to make another video where I go through a very specific court document that I think is relevant to this Owens v. Echard paternity Arizona Supreme Court appeal that is in flight right now. And then I want to make a third video, which is digging into appeals to authority. When can you trust authority figures, and when should you be skeptical of authority figures? And I want to make that video maybe a little cross-listing with my management series. But for right now, we're going to get into this comments section. Now, as of tonight, it's June 4th, 8 p.m. Pacific Standard Time. We have 45 comments. We're going to go through them right here in this video. So sit back, relax, have a beverage, and let's get into it. Now, in response to this video, Frankenbacon says, guys, I can't. Maybe I can. Frankenbacon says, David, if this truly is a watershed moment and you are in the right, then it would set a scary precedent if the ruling stands. Interesting. So where are all the Arizona lawyers stepping up to defend your position? Where's even a single amicus brief from an Arizona attorney who would be adversely affected by this? Interesting. If it's true that you need to be a federal litigator or have expertise in Arizona law to have a qualified opinion here, then why do so many Arizona lawyers involved disagree with you? You made a big deal about the Court of Appeals being a 3-judge panel, but now you're acting like it was just one confused judge. In fact, all 3 judges, each licensed in Arizona, disagreed with your argument. Yeah, I mean, we've got, on this case, we've got Judge Mata, the presiding judge for the original action. We've got Judge Fisk, who ruled on post-hearing motions. And we have the 3-judge Court of Appeals, which is actually in Tucson instead of Phoenix. So that's quite a variety of judges that have worked on this case. Attorneys like Mata, Woodnick, Marcus, and their firm, all Arizona lawyers oppose your view. Well, I mean, I would expect the lawyers for Clayton's side, Woodnick and Marcus, to oppose his view, of course, because they're representing their client. But even if we ignore them, we've still got Judge Mata, Judge Fisk, and the 3-judge Court of Appeals panel. So where are the legal professionals who actually agree with you? Because honestly, I haven't seen a single one. And that's true. Even outside of Arizona, we haven't seen a lawyer that looks at cases, commentates on cases, take David Gingras Esquire's position in this case. They've all taken variations of the opposing position or Clayton's side of the case. And outside of Arizona, that's quite a few lawyers. We've seen MG Law, and in the beginning of the case, we had Legal Vices, Jeff, rest in peace, and Omar, the tilted lawyer. And we've seen Rachel Juarez. We've seen Boss Attorney Bree. And if I've forgotten someone, we've seen so many. Ian Runkle in Canada. I mean, there's just a bunch of lawyers who've looked at this case and just don't agree with David Gingras here. So that's where we're at. And even members of the public who aren't lawyers, it's hard finding people who agree with him. If we could find someone who agrees with Laura, Miss Owens, agrees with David Gingras Esquire, her attorney, about the paternity action, about the appeals, it would be very interesting to hear from them, talk to them, but I can't seem to find anyone. Let's see what he says in reply to this nice post. He says, amicus briefs aren't filed at this stage. I mean, you know, any unrelated lawyer who's not a lawyer for the petitioner or the respondent in this case could just talk about it or give their opinion. They don't actually have to file an amicus brief. I actually don't know when you can file an amicus brief. We had the original court action. We had the original appeal. We had the motion for reconsideration. All of those are done. We're in the middle of the process of his filing for the Arizona Supreme Court. There were no amicus briefs on any of those other earlier cases either. So, I mean, I think the problem isn't that there's a problem with the timing of when you can do an amicus brief. The problem is there's nobody who supports his position that would file an amicus brief. So I don't know. He's got bigger problems than the timing. That would happen later if the Arizona Supreme Court grants review. Very good. And yes, I agree. The Court of Appeals ruling was written by a judge who accepted false statements of law. A judge who accepted false statements of law. He agrees. That's it. Well, that's his opinion, I guess. I don't know if he's making a statement of fact or a statement of opinion. This is the problem with this guy. A lot of the times, it's very unclear to me whether he's trying to make a statement of fact or a statement of opinion. I think what he's saying is it's his opinion that false statements of law were provided by Clayton's counsel and that a judge accepted them. In any case, as for who is right and who is wrong, we're still waiting to see what the high court says about this. Yeah, so I guess it's all opinions all the way down. It's turtles and opinions all the way up, all the way down. That's what we've got. I am realistic and understand the odds are, why does this not expand out? The odds are ... where'd the rest of this comment go? I mean, the odds are stacked against them. I don't know. Maybe he ran out of characters for this comment. I don't think there's a character limit, though. This is weird. Okay, let's go to the next comment. This is a very good one. This is L Reactor. And of course, L Reactor and I had a great discussion on Lauren's channel about the different subsets of appeals to authority, when they are valid, when they are fallacies, when they are dubious. And maybe I'll make a video going over all that. It's very good stuff. Let's see what L Reactor has to say. Just some logic and ethics here. By the time the safe harbor applied, there was already a counterclaim by Clayton, affirmative non-paternity. She was free at that point to drop her claim, paternity. And she didn't. I don't know. I think it does. Do they mean they did? I don't recall. But she was not free to make Clayton's counterclaim, non-paternity, go away. That's the important part. That's the important part. She can drop her claim of paternity saying, hey, Clayton got me pregnant. She's not free to make Clayton's counterclaim because he responded to the original filing. So there was an original filing. That's the start line. So they kicked off the whole court action, and Clayton responded. Now, if you want to dip out before the first response, you can, of course, but Clayton responded, and he asked for a ruling on non-paternity, and he also asked for fees and sanctions and a ruling on that. So there were multiple things Clayton was asking for that still needed to be resolved before the court. You can, of course, just say, look, I'm not interested in my claim of paternity anymore, but you still have to complete the court action with these counterclaims, non-paternity, and fees and sanctions. Think about it this way. If she's saying, Clayton got me pregnant, when you start out, it's sort of like she's saying, hey, NBC is on the television right now. Okay, the TV's turned on, it's tuned to NBC. That's her claim. And, Clayton is basically saying, I want a judge to give me a ruling of non-paternity, which is basically saying, I want a judge to agree with me that NBC is not on the TV. Clayton's not making any specific claims about what is on the TV. The TV could be off, or it could be on ABC or CBS. He's just saying, I need a judge. She's claiming that the TV's on NBC. I disagree. I want a judge to agree with me that it's at least not on NBC. I don't want to say whether the TV's off. I don't want to say whether it's ABC or CBS. I just want a judge to rule that the TV's not on NBC. So he wants the ruling of non-paternity. That's going to be good for his career in terms of dealing with the things she did, like get jobs canceled that he had and things like that. So he needs to clear his name with a ruling of non-paternity. He's asking for fees and sanctions. And the carefully observant will note that in the February status conference, Miss Owens and her attorney at that point asked for fees and sanctions as well on their side if the judge was going to rule in their favor. So she didn't just want to dip out. She kept going, and in February made her own requests. Okay, L Reactor keeps going. In your brief, you seem to forget that a lack of finding of paternity or dismissal of the case without prejudice is completely different than a finding of non-paternity. Exactly. And I think my TV on-off analogy maybe helps illustrate that. I'm not sure. In any case, I'm trying my best here, guys. She can't then just take her hands off the wheel in the middle of traffic once she chose to get on the highway, because he has this whole analogy of, if you're going on a road trip, you start, you drive, you end. And if you're on the highway and you want the safe harbor, it's like getting off at an exit. And the problem is that a road trip, you just have a car, and it's like the car's going from point A to point B, and it's one car. Clayton made counterclaims. So this is more like multiple cars all driving around at once. So even if one car gets off the exit ramp, there may still be other cars on the freeway you have to deal with or keep track of. Okay. Maybe you have a convoy, and I think in this case, we got a great big convoy across the USA. And that's what he's trying to say here. In any case, also factually, what's your evidence that she would have gone along with dropping the case in the fall? She was pretending to be pregnant at that point while vigorously litigating her claims. Yeah, that she wasn't pregnant in the fall was only admitted by her in the winter. Yeah, so at the end of December, that's when we learned that her theory of the case, or her testimony, was that she learned she was no longer pregnant, or not now pregnant, in the middle of November. Okay, so after the middle of November, things go kind of quiet on her side, apart from, spurious Medium articles that talk about pregnancy in a way you could argue are in the past tense. Okay, she's very careful with her wording. And of course, the crying Facebook video, again, you can watch that and check the wording, because she's not making claims at this point in the second half of November and December and January up to the February status conference about being currently pregnant. Now, I hear there's a Reality Steve email in December where she may claim that she's pregnant. I don't know if that email is something where it could be interpreted as being past tense pregnancy or current tense pregnancy. Only Reality Steve could tell us that. It would be interesting if he would do that or release that email. In any case, that is the comment here from L Reactor. This is the best comment, I think, on this video, and I wanted to get to it there. And of course, Mr. Gingras Esquire does not reply to it. Okay, let's move right along. Here's the next comment from Joy. The irony is that your actions are likely as much to blame for Laura's prosecution as hers. You have been unnecessarily nasty and sloppy every step of the way. Oh my, hot takes coming in. You angered a judge, and now your client is going down for fraud and perjury that you knowingly allowed her to commit. I would call you a troll, but you are much more sinister than that. And yeah, if you go through the 7 felony indictments that Miss Owens is being charged with, multiple of those indictments, I think, are in the timeline in which he was her attorney. Some of them are not. Some of them are before his time, but some of them are. Okay, and I think that's the point there with that comment. Greg over here says, Greg Beck. No, everybody's Greg, right? No, this is Greg Beck. Okay, as impossible as it seems, you appear to be even worse at making analogies about litigation than you are at litigating. And again, he's referring to this driving analogy, which I thought was not very good. No analogy is perfect, but I thought it didn't take into account the counterclaim argument, which we've seen before. Okay. Erica says, this analogy is ridiculous. You can't get clocked going 90 in a 45 and just slip into your garage to get away with it. And I guess that would be the idea that if you could just say, hey, somebody invoked or talked about Rule 26, filed a motion for Rule 26 sanctions, in addition to other sanctions, Rule 25 sanctions, for example, and then withdrew the Rule 26 sanctions, you can just drop the whole court action. That's not how it works, because, of course, that would be, in his analogy, like going from 90 to 45 and just slip into the garage on the off ramp to get away with it. Now, he does reply here. He says, sorry, that isn't how the rule works. If you were a litigator with experience dealing with the safe harbor, you'd know that is exactly what the law says. And I don't like this at all because he just sits here and tries to insult Erica by saying, you know, you're not a litigator. You don't have experience dealing with safe harbor. You don't know exactly what the law says. This is just really rude. And he's trying to undermine Erica with a sort of negative claim of authority, a lack of authority, and he dismisses her argument based on that. What he really should do here in this second sentence is, if he thinks Erica doesn't understand the law, he should go copy and paste the law in here with quotes or do some sort of citation and then explain how she's misinterpreting it. So cite your sources and then explain why in a friendly way. And of course, he doesn't do that. And what he does respond with is something very unfriendly. So I don't like this. He says, you can bring 100% false claim and you cannot be sanctioned as long as you withdraw it within the safe harbor window. Now, I think that's his opinion, but because I think my understanding of this is, if you file the claim and if the other party, the respondent, hasn't filed a response, then yeah, you can drop out. You can say, oops, my bad. But in this case, Clayton filed a response before Miss Owens dropped out. Now, if he's talking about the Rule 26 specifically, Clayton's lawyers introduced, they said, hey, we're giving you notice, we're going to do Rule 26 sanctions. Later, way past the 10-day safe harbor period, in which nothing happened on the court docket, by the way, we'll go over that in one of the motions I want to read. They filed their Rule 26 sanctions motions and then later withdrew it. And in the withdrawal, they explained, we're only withdrawing this because we can still get fees and sanctions under Rule 25 as requested in the original response. And we could argue that we're correct about our Rule 26 sanctions, but we don't want to spend the extra money for the clients in this case. Okay. So that's what happened there. Let's see. There can still be other consequences, but not fees or sanctions. That's kind of wild. I don't know why he thinks you can't get fees or sanctions under Rule 25 or ARS 25, I should say. It's very bizarre. He hasn't explained this. He says, I know it's hard to accept this, but that's what the rule says. Well, here's the thing. He's telling us he's not showing us. Go get the rule that you think verifies this and put it in this comment. There's no character limit on these comments, but he doesn't do that. He just says, here's a claim. That's what the rule says. Like, put the rule up and then highlight the part you want to highlight and explain it. Like, it's not difficult, but he doesn't do that, and it's disappointing. Okay, and he says, and it exists for very good reasons. Every lawsuit by definition involves two sides who think the other side is wrong. Okay, just because you think the other side is lying doesn't mean they are. That's true. They could be mistaken. They could be speculating. They could be stating a matter of opinion instead of a matter of fact. Okay. This is why, or they could be right instead of being wrong. This is why parties are allowed to bring claims, even if the other side says they're 100% wrong. Okay, yeah, I mean, you go to court and you have a disagreement, so you go to court. Thank you, buddy. Okay, it's only when the facts show a claim is totally groundless that sanctions come into play. I don't know. I think the judge can award fees and or sanctions in family court for pretty much whatever they want. I don't know what he's talking about here. But in order to stop people from seeking sanctions in every case, well, they were seeking fees, not sanctions. But anyway, the rule requires people to go through this notice and warning period to give the other side a chance to voluntarily drop their claim for Rule 26, but not for Rule 25. Oh boy, or ARS 25. So he's ignoring ARS 25. He's not bringing it up. I don't know why. Exactly as Laura tried to do here. I think he thinks if somebody mentions if somebody mentions Rule 26, it supersedes ARS 25, which I think is, my understanding, that's not correct. That would be very strange because nobody would ever even utter the word Rule 26 because it would be like the boogeyman or something, which is kind of bizarre. Nobody would ever use it. It would relegate it to, deprecation, basically. Okay. And then Greg Beck replies and says, so you're saying your analogy sucks. I think you may have stumbled onto something people will agree with. Oh boy. Yeah, they didn't really, I don't know. The analogy doesn't do much for me. Sometimes they're okay, but often they can be a little confusing unless you're having a dialogue. And of course, I made my own analogy here relative to the TV and the TV channels. If you have questions about that, or if you think we can make that better, put something in the comments section. That would be great. Okay. Linz says, David, we're begging you, stop talking about Rule 26, move on. Also, it's Laura's behavior that people hate. Yeah, because he talks about haters and yeah, I don't know. I don't really hate Miss Owens. The behavior, yeah, it's not good behavior from all the evidence we've seen in terms of where we are. And of course, we've seen that others agree in terms of this ruling and the felony indictments that she now faces. I think the county attorney and the county attorney investigators agree that her behavior needs to be dealt with in some legal fashion. Okay. from the side of criminal law. Okay. Allie says it's like the only class he showed up to in law school, and he thinks it's all he thinks he knows. Okay, so they're talking about Rule 26. I mean, the Rule 26 thing is interesting, but the problem was the whole Rule 26 was withdrawn. Rule 26 was, noticed, 10 days passed, they filed their motion, they withdrew their motion. I don't see any problems with it. We've got a award of fees under ARS 25. I don't see the problem. Neither does, Judge Mata, Judge Fisk, and the 3-judge appeals panel in Tucson. Gosh. Okay. Comfy says, I think you're confusing Rule 26 with Rule 34 the same way you're confusing portrait mode and landscape mode. Oh no, trouble. YouTube is tough, guys. It's tough out here making videos. I had to wait until 8 p.m. to make a video because I had contractors here all day. They're pounding away, they're sawing. They got drills and saws and all this jazz, fixing things up and painting, and there's tape everywhere. And I just couldn't make a video. So now here we are doing it now. Cat Lady Ballerina has entered the comments section. Cat Lady Ballerina, our good friend, says, what if Rachel Mitchell has proof that Laura was pregnant? I don't know what that would be. I mean, she's been running around subpoenaing things, apparently. I assume she has. And that's a quote from David S. Gingras, Esquire, in his interview with Reality Steve and Rachel Juarez. Go check that out. That was a pretty interesting statement there at the end of the video. She says, you call that backtracking on not knowing a subpoena versus a search warrant when the police report from the search warrant indicates Laura called her attorney for legal advice. And then you disclosed it during a YouTube video in April when no one knew about it. Hashtag yikes, David. And of course, we saw in the search warrant documentation that Laura locked herself in the casita so she could call her lawyer. We assume it was David S. Gingras, Esquire, that she called at the time. That was the end of January 2025. So I don't think she'd retained her current criminal defense attorney at that point. Probably wasn't calling him, but you never know. In any case, whoever that lawyer was, they advised her to cooperate with the police, which was the correct call. But yeah, he did sort of hint at these subpoenaing things. And there was actually more of a search warrant being executed at that time, which presumably, if he was the lawyer she called, he knew about. Very interesting stuff. The Moon Bump. The Moon says, who is paying for Laura's Barry's membership? Yeah, apparently she likes going to Barry's boot camp. I don't know what that is because yard work is my gym. I don't have a gym. I just have mountains of yard work I need to do. That's how I stay in shape. Cat Lady Ballerina says, so, are you aware that Woodnick was on the committee that wrote Rule 26? And Gingras says, literally mentioned this in the video, and so what? That makes it doubly inexcusable that Woodnick didn't understand the rules. And again, this is his opinion. It's his opinion that Woodnick and Marcus don't understand the rules. But it's very weird. The bar is very high here. This is a very extraordinary claim to say that Woodnick and another attorney, Marcus, don't understand the rules when they won their case, they won their appeal, they won the motion for reconsideration. It almost sounds to me like they do understand the rules because they keep winning. So if he wants to argue that they don't understand the rules and should lose, he has a very high bar in terms of the evidence I would require to believe his claims. Extraordinary claims require extraordinary evidence, and he just hasn't done it yet in a way that will convince us, or at least in a way that will convince me and a bunch of people I know. Okay, Ali says, is this the only class you attended at your hashtag 120, 150 law school? What does that mean? Hashtag 120 out of 150. Guys, what does that mean? If you understand that, put it in the comments. It's the only thing you ramble about. Okay, so it's all about Rule 26. Oh boy. Cat Lady Ballerina says, yes, it makes total sense that every single person in the world is misinterpreting Rule 26, but you, standing alone, and are the only one who understands it. Yeah, this again goes to the idea that we'll cover in another video in more depth about appeals to authority. So, in life, sometimes you have to just trust that the authority understand in a certain subject will have the answer and defer to them. Like I'm not a rocket scientist. I have to defer to rocket scientists and their expertise because I can't be an expert on anything and everything, including rocket science. I have to defer to IT goatee Brad because he knows way more about rockets than me. Now, the time you shouldn't defer maybe blindly is if you are taking the minority position. It doesn't mean you're wrong. It just means you have a much higher threshold that you have to reach in terms of providing good evidence for your claims, right? Like at one point, probably a lot of people thought the earth was flat. Somebody went and did the Eratosthenes well experiment or something like that, figured out the earth is not flat. And it might have been the minority opinion at some point in time. So they had a very high threshold to cross. And of course, if you go do the Eratosthenes well experiment, you can see the earth is not flat. So it works. They were correct. But you have to provide great evidence that is independently verifiable and repeatable so that other people can get on the same page with your minority opinion. Okay. Anyway, enough about that. Let's see. We've got Kelly Ballerina. She says, by the way, how are all those bar complaints going for you? It's like, 11 now? Are you just responding to them all by saying, but Rule 26, and then arguing Rule 26 incorrectly ad nauseum? We don't know how he's responding to all these bar complaints. I'm sure Bar Guy is very busy. Hashtag tots and pairs for Bar Guy, dealing with nearly a dozen bar complaints. Oh boy, put in the overtime, buddy. Let's get it done. Okay, next comment from Shivy. Laura didn't file within the 10 days, so the argument is mute. I think they mean moot. Even if you were right, which you aren't, go away. Yeah, I think they missed the 10-day window there. In any case, let's see. Alligan says, David, you're making an absolute fool of yourself. Oh boy, hot takes coming in hard. And it's getting beyond sad. Why, 4 whys, should we believe you? Exactly. You have to explain why, not just what. The courts disagree with you. Evidence disagrees with you. The law disagrees with you, no matter what straw man argument or nonsensical analogy you come up with. And you and your client have changed your story, her story, hundreds of times at this point. I don't know about hundreds, but probably a few. Give it up. Find your passion or something you thrive in. Please think about taking some accountability for being misogynistic, racist to Greg's wife and Rachel Juarez, who schooled you, by the way, fat shaming to an undeserving Megan Fox, who looks amazing, and her mentioning your cat is tubby didn't warrant that. You clearly have a ton of mental health issues, like your client needs serious help. I mean, yeah, I've seen a lot of rudeness and anger from this guy when he's doing comments on Twitter or YouTube, that sort of thing. I think some therapy in terms of not being rude on the internet would probably help, but you have to want to get help in order for the help to work. So that's what we need. Okay. Playing the everyone is wrong and I'm right card is pitiful at this point. Move on, make better decisions, and try to be half the lawyer Woodnick is. Work on your reactions and how you treat people. That's good advice. You only live once, and having your legacy be tarnished with being a hateful human and defending a criminal is not the way to go. Be thankful you have your mom to fund your lifestyle and maybe find a new career, since being an attorney isn't working out. Ooh, wow. Tough message there, but maybe we can learn something from it and just be a little self-reflective, have some grace, but also try to be better tomorrow than we are today. JB Sack said, JB Sack, JBS ACK, I don't know. Let's see, JBS ACK. The court disagreed with you. The appeals court disagreed with you, and so will the Supreme Court. Give it up. You're making yourself look almost as foolish as your client. Oh boy, that's tough. Julie says, how about if we explain how wrong you are in the same condescending tone that you use? I don't recommend that. I think we can just try to be skeptical. We can try to have some grace, but we can hold people accountable at the same time. And that's the best we can do, guys. We're doing our best. Robert says, the math ain't mathin'. 2 years ago, Laura said in documents that were submitted to the court that she had $400K. And I think it was closer to $450K. But yeah. Last year, she said she made between $100,000 and $200,000 per year. Right. And then in June 10th, she said split with her mom. And she confirmed that as well. You said she is out mid 5 figures. Okay, so that would be like $10,000 to just under $100,000, somewhere in there. So unless she lied or is hiding assets, she should still be able to pay Clayton tomorrow. Well, tomorrow. I mean, tomorrow. It depends on if the banks are open, but yeah, something like that. Let's see. So Gingras says, no, you just don't know the facts. Oh boy. So let's get into the facts, I guess. That $400K, and again, it was closer to $450K. It was like $449. I don't know. Anyway, details. Attention to details, guys. I'm here for you. Was from an investor, which Clayton was fully aware of. This is interesting. From an investor. That's weird because in the court documents, she said the money was in her account. That's very strange. Okay, anyway, or it was her money in her account. He specifically talks about this in his deposition. Well, that's convenient because we don't have the deposition, so we can't independently verify his claim. Oh, well. So that $400K, again, it was closer to $450, wasn't Laura's personal funds. Oh, dear. Well, her statement in a document that was submitted to court certainly made it sound like they were her funds. It was an investor's money she was going to use as part of something called the Morby method. Oh boy, the Morby method. But when that deal fell through, because Clayton lied to Laura and never submitted the purchase offers, the investor kept their money. I don't know how I feel about that because that's weird. Like, why would a deal fall through because Clayton didn't submit the purchase or offers? Clayton has said repeatedly that he told Laura she should just take the offers to a different realtor and do the deal with a different realtor. And it would be the easiest money that realtor could make because the offers were already written up. And she refused to do that. If she was very invested in getting this deal done, that's what she would have done. She would have said, okay, Clayton, you don't want to do the deal. I'll take the offers that you wrote up, go to one of your associates or even a different realtor, get a recommendation from her parents or something, and go do the deal. Why didn't she do that? It makes you wonder, right? Like, why didn't she do the deal? She could have done the deal with or without Clayton. Clayton didn't submit the offers. She could have kept trying to do the deal with Clayton, or she could have taken the offers somewhere else when he suggested it. If she really wanted to do the deal, she would have done that, in my opinion. This is very suspicious. So I don't buy this argument. He talks about it as if it's a fact, but it's more of a opinion or a hypothesis. He's speculating about this. So that's interesting. And who is this investor? Very weird. And who just gives somebody, a private citizen like Laura Owens, $450,000 as an investor to go buy 2 Airbnb properties? Who does that? That doesn't make any sense. You would fund the deal at closing. You would not just hand somebody a pile of money, cross your fingers and hope they do a good deal for you. Doesn't make any sense. So I think there's something he's not telling us here, or he doesn't know the whole story. And as for Laura's $200,000 income, that was the revenue her podcast earned in the past. Well, she said it was current as $200,000 a year split with her mom in the June 10th hearing. So I don't know how far in the past it was. That's weird. Now, they've been recycling podcast episodes for quite a while, many, many years at this point. So I can imagine they weren't making any money off of recycling episodes. So that kind of makes sense. Which she split with her mom. That's fine. Okay. Sadly, JFC harassed Laura's advertisers, resulting in the podcast income vanishing. And again, I don't buy that argument because, number one, he doesn't provide any evidence that anybody harassed an advertiser, number one, or that advertiser vanished the income in response to it, number two. You'd have to prove both those things with evidence, and he hasn't done that. These are just claims with insufficient evidence. The other thing is, if she was recycling episodes for way long before the Clayton case, how could anybody harass her advertisers? Her podcast wasn't fresh by the time this case started. So I don't buy this argument at all. It just doesn't make sense. So no, Laura is not going to pay Clayton tomorrow or ever because she can't. Oh boy, this is a bummer. She could get a job at Lowe's or Home Depot or something and start paying Clayton. I don't know. Anything. I mean, if the podcast isn't making any money, she could do something else. How's she paying for food? This is crazy. Clayton and Woodnick set out to destroy Laura. What? She filed the case. They were the respondent. She went to the Sun, the tabloid, and they had to respond. They didn't set out to do anything but defend themselves. The Green Bay Packers don't put their defense on the field unless the Minnesota Vikings or the Chicago Bears or some other team puts their offense on the field first. And that's exactly what Woodnick and Clayton did. They were defense. They were the respondent in the case. They did not take the story to the media first. They're playing defense. So I disagree with this statement as well. And their plan worked. I mean, they won their case. If you call that a plan working, jeez. Hopefully, when all this is over, Clayton will end up writing Laura the biggest check you've ever seen. Fingers crossed. I mean, if wishes were unicorns, my garage would be full of invisible unicorns right now. Fingers crossed. What? This is weird. Just, hopefully I win the lottery tomorrow. This guy. Hopefully. That's how you know he's got a great argument. He's got his fingers crossed, guys. That'll do it. That'll get it done. Oh my gosh. Okay, let's see. Then he says, Mrs. Jessica Smith. Okay, we don't have a Mrs. Jessica Smith. Oh, you know what happened here? I think somebody replied to him and he deleted their comment, which could be okay. Like if it was a troll or something, or someone made a rude comment, it's okay. You can delete the comment. He says, but he's replying to a comment that we can't see. He says, Mrs. Jessica Smith, this comment is so dumb, so disrespectful. Words fail me. Wow. I'm left with nothing else to say but F you. I am muting your psycho ass from my channel. So any future comments from your heartless, rotten soul will be invisible to me. this is, I don't know. What is this guy doing? He's just, I feel like he's got anger issues or something. Anger management bear has come out of the woods, guys, and needs to help us. He sounds so angry, and we don't even know what the comment was. I mean, even if it was like a really, really rude comment and it was like a troll or something, what you do in terms of moderation is you just delete it. You delete it and give the person a timeout, or you ban them from the channel or something if it's really egregious. You don't need to reply to it with all this anger and vitriol. I mean, he calls them a psycho ass. He says they have a heartless, rotten soul. This is really angry dialogue here. Like, it just seems like an anger man. Like, if I was leaving a grocery store and there was like some people at the entrance of the grocery store and one of them was yelling at the other one saying, "You're a psycho ass. You have a heartless, rotten soul. Get out of the store." So, like, I would want that person to seek therapy for their anger issues. I mean, I understand they probably deleted a really rude comment or something, but like, just delete it. That's moderation. Oh gosh, that's wild stuff, guys. Wild stuff. Schnitzel Ninja 69 has entered the comments section and says, "Interesting twist, but here's the problem. In her deposition, Laura allegedly claimed the $400,000 came from an investor. Fast forward to the June 10th trial, and suddenly she's testifying under oath that the money was hers, sitting in her own money market account. No mention of an investor, no Morby method, just a complete 180. Yeah, so this is very strange. Yeah, so there was a, what is it? The pretrial motions, stipulations. She says, this is my $450,000 in my account. Apparently in a deposition or in the June 10th trial, or now her lawyer is saying, no, it's from an investor. So which version are we supposed to believe? The deposition or the sworn trial testimony? Because both can't be true. Yeah, exactly. Either it's your money. I mean, it's your I don't know. Like, if an investor gives you money, it's not really your money, even if it's sitting in your account. And so the details matter here, This whole thing is starting to feel like trying to follow a GPS that keeps rerouting every 2 minutes. 1 second you're headed north, the next you're somehow in a lake. Oh my gosh, guys. If you find yourself driving into a lake, hit the brakes. But the voice just keeps saying you're on the fastest route through the duck pond. Oh my gosh. Would you trust it, or maybe start to think something is off? Yeah, I mean, the whole thing is very suspicious, right? Like, what happened to this $450,000? Whose was it? If the deal was to do 2 properties with this $450K, which were the Clayton offers, why didn't another realtor just handle those offers? It's very confusing. I don't understand. There seem to be some contradictions here in the publicly available court documents, at least the pretrial motions. I don't know anything about the deposition because depositions aren't publicly available, but definitely pretrial affidavits and trial testimony appear to be in conflict. If the facts keep contradicting themselves, maybe it's not the map that's broken. Maybe it's the driver. Exactly. Very good. Okay. Cat Lady Ballerina. This is a big thread. This is an interesting topic. Says, "Hey, ding dong, you submitted an affidavit to the court from Laura saying she had $400,000 in the bank. Did you purposely elicit perjury by Laura in the affidavit?" Good question. "At this point, it seems like you're begging the Arizona bar to set your bar card on fire and retire you in shame." Yeah, this is a good point. This is the affidavit for pre-hearing for June 10th. And then in June 10th, you can go watch the actual video. Deandra says, okay, you submitted that you had $450,000 in this money market account. And then Laura says, I don't have $450,000 in a money market account, which is basically like, I don't have it today. But we don't get any details about what was it doing when she and Clayton started doing real estate work. It's very mysterious. Mysterious stuff. At this point, it seems like you're begging the bar to set your bar card on fire. Yeah. Okay. Ashley says, respectfully, can you address the comments below where people explained Laura stated the money was in her checking account and provided a bank statement as evidence? And can you also understand why people don't believe Laura? She just doesn't make sense. Okay, that's good. I agree with that. Let's see what else we got. I was pregnant at the same time as this case and fully believed Laura in the beginning. But having no evidence of pregnancy and little to no fetal DNA just makes no sense at that stage of pregnancy with twins. Even if she lost them in July, which also makes no sense for a litany of reasons. Yeah. And remember, we have no clinical evidence of pregnancy in terms of ultrasounds or fetal heartbeat monitoring. We have no clinical evidence of any miscarriage that occurred. Oh my gosh. We have no determinant results from DNA testing for paternity. And we have no babies. So we don't have anything except a handful of blood and urine HCG tests. And of course, HCG is merely an indicator of pregnancy. It is not proof of pregnancy. Okay. Mia Wallace says, Clayton and Woodnick set out to destroy Laura and their plan worked, quote unquote. Laura set out to destroy Clayton's reputation by going to the media and posting on Reddit because she cannot handle rejection like a normal, emotionally stable person. F around, find out. Fixed it for you, David. Yeah. She went to the Sun tabloid. She went to Reddit. She filed a paternity action in court. Clayton was on defense in this game. Defensive MVP for the Super Bowl of Clayternity on June 10th, in my opinion. Linda says, if Laura can't pay Clayton, how is she paying her criminal defense attorney, going to Barry's boot camp, and participating in expensive horse competitions? She's getting money from some source. Good question. Okay, and of course we have no answer. Julie says, hearing you talk about Rule 26 is like counting sheep. It puts me to sleep. Oh, no. He says, your opinion isn't the one I'm trying to change. That's interesting. I mean, whose opinion is he trying to change? And if he's trying to change opinions, I mean, I don't think he's done a good job because he's making a minority opinion here. He has to have very, very substantial evidence for me to believe his claims because it just doesn't make sense. I don't think he hasn't explained why he thinks he's right in terms of any good arguments. I think the best analysis of this Arizona Supreme Court appeal document was done by MG Law, who went through it with a fine-tooth comb and cited his objections to it. And until Mr. Gingras offers something that counters those ideas and arguments, I'm just not going to be convinced, probably. And that's where we are. Let's see. Julie says, all the best in trying to change anyone else's opinion. Yeah, I don't know whose opinion he's trying to change. I don't know who his PR is for. I think it was the primary error for him in this case was trying to do PR like this and be a lawyer at the same time. It's a conflict of interest. It makes your PR biased at a minimum by appearance, if not in actual reality. The appearance of impropriety and the appearance of bias when you're doing PR and being a lawyer at the same time, it just doesn't work. Okay, Allie says, good news, you're not changing anyone's opinion, smiley face emoji. You've proved your crush. Dave Neal's argument more than anything. Great litigating. And again, I don't think Dave has a legal argument in this case. I think Dave's position is, look, this lady said she was pregnant. She said she was pregnant with twins. She said she was pregnant with Clayton's twins. Show me the evidence. And I haven't seen it. That's Dave's position. And his other position is, look, there's this whole legal wrangling about Rule 26 and all that jazz. If she were to win an appeal on some technical issue, some procedural issue, some obscure corner case rule of law. It doesn't change, the appeals don't change the facts of the case and the findings of the facts in the case. And that's really what Dave Neal is interested in. That's primarily what I'm interested in as well, although I find the legal arguments interesting for sure. Okay, Lisa, why haven't you figured out yet that Rule 26 is dead and gone? You need to move on. Tell Laura to pay her bills and pray she's able to stay out of jail. Exactly. That's the adult responsible thing to do. Pay your bill and move on with life. She doesn't seem willing to do this. Pacific Northwest Mama Bear says, Davy bro, my dude. I feel like we all face a moment like this in our lives when you have to reflect and realize we are just as fallible as the next person. Oh boy, we're getting philosophical here, guys. You clearly are not lacking in intelligence. It's how you apply your abilities that need work, I think. Ask yourself about the actual probability of all the lower and higher courts, as well as all of the folks that have kept up with this situation, all being incorrect. That is exactly what you suggest all the time. According to you, we are all Greg, and only you and Laura know the law and the truth accurately. How does that possibly add up? I try to not comment or bother you, but it's almost impossible to have the willpower when you spout off like you do. Also, you say you despise Trump, but you are equally unhinged and strangely invested in bringing him up all the time, in my opinion. All the best, heart emoji. There we go. Okay. And he does reply here. Let's see what he has to say. He says, this comment, while a little negative, has some value because I agree with you. Only a fool will dig in his heels and insist he is never wrong. A wise person, even when you win at first, will always stop and reevaluate. A wise person is always open to the possibility that they're wrong. I fully agree with that, and I embrace it without any hesitation. Well, that's good. Oh boy, this is a big one, guys. This is a big reply. Ooh, are we ready? But after being involved in this case for over a year, I have done exactly that. I have stopped many times to ask, are you right about the law or are you missing something? As part of that, I have carefully read and considered everything Woodnick/Marcus have said. I carefully read every word Mata wrote and everything the Court of Appeals said. Okay. Based on all that, my view is actually stronger than ever. I am 100% right about the way Rule 26 works. Well, he has an opinion that he's right. He can't make a statement of fact until he has, reasonable evidence that we can agree on. So far, it's his opinion. He conflates statements of opinions with statements of facts. I'm 100% right about the way Rule 26 works and how it should have impacted the case. And before you say that lots of judges have disagreed, that's simply not the case. Mata, who is the worst judge I've ever encountered. Dang, guys, you can go watch a video of the February status hearing and the June 10th evidentiary hearing, and you can read her minute entry rulings and the final ruling of the case and make up your own mind as to whether she's the worst judge you've ever encountered. I mean, that's really extreme. I don't know. Let's see. Mata disagreed, and one judge appellate judge accepted Marcus's logic. Yes, the decision was 3-0, but I don't believe the other two judges spent a lot of time pondering the issues. Why does he believe that? What's the evidence for that? Is he speculating? Is he guessing? Is he hoping? Is this another cross your fingers moment? Why does he think one judge spent a lot of time pondering the issues, but the other two didn't? There's no evidence of that. This is very strange. It's a little rude to say that 2 appellate court judges didn't do their job correctly. Wow. It's also rude to say Judge Mata is the worst judge you've ever encountered. I mean, I don't think she did anything. If you go watch these videos, February status conference, June 10th evidentiary hearing, if you read the minute entries, she seems perfectly reasonable to me. She's doing her job. It's family court. The bottom line, as I've pointed out many times, is that just because a court rules against you does not mean you're wrong. Okay. But, you have to provide evidence. Like, that doesn't mean you're right either. Like, you have to provide good evidence. Tons of people have lost in the lower courts and then won at the Supreme Court level. Tons. I mean, tons is like, what is tons? It's not a quantitative number. It's a qualitative sort of assessment. Tons. How do I measure tons? My understanding is that appeals are successful way less than 50% of the time. So, yeah, there are people that are successful in appeals, but not at a, greater than 50% success rate. So the odds are stacked against you when you appeal, because the courts do as good a job as they can at getting it right the first time. Okay. And the higher up you go, the smaller that percentage of appeals winning gets. And he's already gone past the regular appeal, the motion for reconsideration. And now he's at the Arizona Supreme Court. The chances are so slim. But he uses this all caps word tons, which again is not quantitative, it's qualitative. What does it mean? It doesn't mean anything. It's just rhetoric. In this case in particular, the Court of Appeal literally ignored all the cases I cited. I think they said your argument has no basis in law or fact. So they didn't discuss a single one. Yeah, why should they? Your arguments didn't warrant a discussion. That's a sign. That's a signal. Read the sign and take the signal. Oh my gosh. Why? Because they couldn't explain why I was wrong. So they just ignored legal authorities in my favor and accepted what Marcus said. I'm sorry, but that's not a good reason for me to change my mind. If anything, it strengthens my resolve. So because they didn't hold your hand and walk you through why your appeal didn't win, you think that gives you a stronger argument. Okay, buddy. And one last thing, you fail to understand, this is not my first rodeo. I've had other cases where the plaintiff brought a totally fraudulent claim and then tried to drop it. 100% of the time, the courts have allowed this and have never awarded sanctions. I like to bring receipts, so just look at the docket in this matter. And then he lists Levchenko versus Grant. And we can take a look at this, but yeah, you can drop your case, okay, before the respondent responds. Or there are cases where you can be in a case where the court action finishes and there are no sanctions. But what about fees? Fees and sanctions are different. And he says sanctions, and in this case, we're talking about fees. I don't know. He's being a little deceptive here. Okay, I'm going to take a quick break and let my dog out because she wants to go outside, and I will return momentarily. Okay, everything is good. Let's see where we are in this giant comment here. We need to scroll down a bit. We were at this case citation. He says, this case that he cited involved a 100% fraudulent claim against a client of mine. The plaintiff fought the case for a while and caused my client to incur nearly $30,000 in fees. The plaintiff then tried to drop the case and walk. I asked for fees, and that request was denied. The only punishment the plaintiff suffered was a small judgment for costs. And FYI, I reported this lawyer to the Arizona bar for perjury. Bar refused to even investigate the case. I mean, this is very typical, right? Sometimes in a court case, you have to pay your own fees. You don't just get the other party to pay your fees by default. So I don't know what he's talking about here. It is experiences like this which helped form my views/opinions about the Owens v. Echard case. Laura filed her petition and then tried to drop it. No, she filed a court action and then tried to drop her claim. The problem was there was a pre-existing counterclaim, so you can't just finish the action. The court refused to let her, even though Rule 26 unquestionably gave her that right. Well, I think there is a question about that because that's what you guys are arguing about in these appeals. So it's not unquestionable. It's questionable because you're arguing it out in the appeals. This guy, he doesn't know how to have a conversation in terms of, whether something's a fact or whether something's an opinion or whether something's a disagreement. I mean, it's very bizarre. So let's see what happens. Yeah, because you're questioning each other about it. It's not unquestionable. Oh my gosh, this guy. It's possible the Arizona Supreme Court won't touch this. Okay. But it's equally possible they will take the case. No, that's not true. The Arizona Supreme Court receives requests to do appeals, and then they select a small fraction of them to actually look at. It's not equally possible. Equally possible means 50-50. It's not a 50-50 shot. You have much lower odds than 50-50, statistically speaking. This doesn't make any sense. It's equally possible they will take the case. It is possible, but it's not equally possible. They will take the case and say, I've been right all along. Oh my gosh. And I'm not giving up until the final word has been handed down. Okay, well, I mean, you filed your appeal. Of course, the appeal won't be over until you get a result because you filed it. Oh boy. Let's see. I guess you could withdraw early or something. I don't even know if you can do that. Oh my gosh. This is just rhetoric. Okay, Pacific Northwest Mama Bear has the final say in this epic thread. Let's see what it is. I love that I caused you to monologue. Yeah, and I had to read all of it. Oh my gosh. Smiley emoji. Time will tell. That's all any of us can say right now. Pacific Northwest Mama Bear is very philosophical. I like it. Respectfully, I still believe Laura contributes to nothing positive. Oh boy. I also believe you have harmed yourself teaming up. Again, time will tell as we find out what happens with her criminal charges and your unsettled bar complaints. Ooh. Yeah, tough to sleep at night with felony criminal indictments and multiple bar complaints. I would think. I don't know. That's just me. Let's see what else we got on this post. We're getting near the end, guys. We're almost done. Oh my gosh. Julie says, Jingris, please tell me you realize how insufferable you are. Right? This is your shtick, right? I was watching the Omar the Tilted Lawyer interview with Rachel Juarez earlier tonight. It's a good video. Go check it out. But, they were talking about this dichotomy between the way Jingris can be very pleasant on the phone or when you first meet him, and then he sort of goes off the rails with this rudeness and this anger once you disagree with him or online on Twitter in these comments sections and things like that. I think the rudeness and the anger is the real person, and the shtick is the nice guy act on the phone when he first meets you. But that's just my opinion. I am not a psychologist or a medical professional or anything like that. That's just my personal take on what is the shtick and what is not. Okay. Meow Mix Supreme. Meow Mix Supreme says, hi, David. Super curious. Let's say the process for Rule 26 was correctly followed. I think it was, but anyway. And Laura had not dropped the case. Okay. Would you still have taken this case on? Ooh, this is a good question. If so, do you think that you would have attempted to appeal if Mata's decision was the same? Yeah, so let's say Gingras looked at the case when he was looking at seeing if he wanted to become her lawyer and couldn't find any problems in his mind with the Rule 26 sanctions, or let's say they had never introduced the idea of Rule 26 sanctions and were just focused on ARS 25. Would he have still taken the case on? That's an interesting question. If so, do you think you would have attempted to appeal if Mata's decision was the same? And we get no answer to this question. My guess is that I can't say if he would have taken the case on if he didn't see a way forward with the case. Maybe he would have. I think if he had taken on the case and Mata's decision was the same, he would still be appealing on these Mata issues. You know, he said he thinks she's the worst judge he's ever seen. He thinks there was structural error and all this jazz. I think he would have appealed anyway on some of those grounds, maybe something else. That's my take. Let's see. And the final comment here from Toads. We have some hundreds of views, and the only likes are from you, Laura, and her mom, apparently. I guess there's like 3 likes. Ratios. Okay. The math is mathing. Thank you, Toad. Okay, and we get one reply, which is cults are hard to please. I mean, here's the thing. If there's hundreds of views, over 500 views, you think there's over 500 people in a cult that are like watching this video and no one else, like 3 other people outside the cult? I just don't believe it. Like, where's the general public that's not in this quote unquote cult? And where are their upvotes? Where are their comments in support of your arguments? Why aren't they going to interviews with people on YouTube about why they believe Laura's case should have gone Laura's way, or why your appeals should have gone your way? Where are they? Where are those people? Everybody in the public can't be in a cult. That's just, it's absurd. And of course, I've done videos on this, and I will continue to say, calling a bunch of people in the public domain who disagree with you a cult is damaging to people who are in legitimate cults, people who have survived legitimate cults, people who have family members who've been harmed by being in real cults. Heaven's Gate, you know, Jonestown, David Koresh, the Nixium cult, real cults that have done real harm to people. And he's just throwing the term around. It's dangerous. It's not good. And he's never proven that there's a cult in this case. To prove there's a cult, you have to demonstrate that there's an organization. Of course, in this case, there's no organization. Nobody is my superior boss or manager. I'm not anybody's boss or manager telling people what to do. There's no org chart. There's no organization. Nobody pays dues. There's no membership fees. There's no roster list somewhere. It's absurd. There's no organization. The first thing you have to do is prove there's an organization. The second thing you have to do is demonstrate that that organization is behaving in behavioral, information, thought, and emotional control on its population. Again, behavioral control, information control, thought control, and emotional control. They tell you what to think. They tell you how to feel. They tell you what information you can and can't have. They tell you what you can and can't do. Nobody is doing that. I'm a member of the public. Everybody watching this case is a member of the public. They can do whatever they want. They can think whatever they want. They have access to publicly available court documentation, all of it. And they can feel however they want to feel about it. There's no cult. So this is just, again, more baseless rhetoric designed to insult people rather than coming up with a good reaction that is convincing, that is data, quantitative based, evidence-based, and will convince other people as science enthusiasts, as skeptics. Okay. Throwing around the term cult, insulting people, calling people total fucking psychotic assholes. It doesn't get you anywhere. It's just rude. It's not just bad PR, it's the worst kind of PR. He's engaging in the worst kind of PR possible. And as somebody's attorney for an actively ongoing case. I don't know. I don't know what to tell this guy. Stop doing PR and seek therapy for your rudeness and anger issues. That's all I've got to say. All right, guys, if you've stuck around this long, thanks for your support. I'm Bruce from Oregon, Bruce the Moose with the Bruce from Oregon show. In the empty room. I've got 2 more videos I want to make. We'll see when I can get to them. I will talk to y'all later. Bye.